All right, I see that we are now live streaming. Good morning. This is the Kansas Court of Appeals oral argument document for Thursday, January 13. We have three cases on the docket, the first of which is the matter of the marriage of Kenneth Clark and Nancy Clark. Let me introduce my colleagues. I have the privilege today to sit with Judge Steve Hill of our court. I believe is the longest serving law trained judge in the state now. I'm also pleased to be sitting with Catherine Gardner, who's a member of our court. And I have been on the Court of Appeals for a little over 11 years. So we have a very experienced panel here. I will remind counsel that we have read your briefs. This case is set for 15 minutes of argument per side. If the appellant would like to reserve a portion of that 15 minutes for rebuttal, please let me know at the start of the argument. And I would just suggest you jump right into the legal arguments. And with that, Ms. Webb, I believe you are representing the appellant, so the floor is yours.
Thank you, Your Honor. And yes, I would like to reserve any remaining time for rebuttal.
Well, how much would you like to reserve? You need to let me know.
Let's say 5 minutes.
Well, that's fine.
Okay.
Please proceed.
Thank you, Your Honor. As you know, this case that was filed in January 2002 by attorney Ken Clark is now 20 years old this month. It is the oldest case in Sedgwick County District Court and perhaps the longest running case ever. So how did we get here? The short answer is that petitioner, attorney Clark, knew exactly what he was doing and how it would all play out to his advantage financially and to the detriment of his wife.
Ms. Webb, I don't mean to cut you off. We kind of know more or less how it got here. What is it you want us to do with it now that it is here?
We are seeking an order from this court that the arrearages from the temporary order for child support and spousal maintenance are due and owing. And per Mr. Clark's expert witness, economist, that amount with interest is now approaching $500,000. We feel that Ms. Clark is entitled to those funds because they were always owed. They did not go dormant, as appellee has now admitted, and that would be a significant aspect of the case, of course. We also are requesting an evidentiary hearing that was repeatedly sought and denied throughout the course of the proceedings in the district court, at least from 2015 when I became involved and the case was being prosecuted actively from that point. We want the court to remand that for an evidentiary hearing on the issues of the distribution of the proceeds from the sale of the marital residence that was sold in December 2019. Those funds are being held, I believe, in Mr. Whalen's trust account, waiting disbursement. We think an evidentiary hearing is required on that because there was not sufficient evidence for the district court to have summarily and it was unsupported how he made that division, that 40%, 60%. No evidence supported that. We think an evidentiary hearing is necessary based on due process law and also on the issue of attorney's fees that was never addressed at the district court level. That would be the, pardon?
Well, I had a question.
Yeah.
Your position on the dormancy is that the temporary maintenance did not result in final judgments that could go dormant, correct?
That is correct. And Appellee has dropped that argument. It was raised below, but yes, that didn't go dormant, was not ever a final judgment.
Okay. What is the basis for the interest computed on the support and the maintenance then?
If those amounts are owed, then they accrue interest. I don't have a statute, but I believe that they, as temporary orders, they are collectible and owed, and if they're not paid, they accrue interest.
Well, and that's what I'm a little puzzled. I mean, I agree that they're collectible, but the expert, such as he was in this case, relied on the statute for interest on judgments. And it seems to me, if your position is that the temporary orders are not judgments, I'm not sure why the statute on interest on judgments applies to them either. And so I'm wondering if there's some alternative basis for interest on those amounts.
That is a very good point. And I guess my argument is that if those amounts were owed, even though they were not characterized as judgments for purpose of the dormancy and renewal statutes, they're still owed. And it would be unjust for my client to have not only not gotten paid, but now 20 years later, if interest is not allowed, it just can't be right. But I hear your question of what's the authority that allows for that to be applied. And the expert that Appellee retained was never deposed. And
well, I mean, his report says that he just relied on the statute for judgments. And I mean, having looked at that, I have some question about how a temporary order cannot be a judgment for dormancy purposes, but is a final judgment for interest. And I don't know whether there is some other basis, because it's not discussed in the briefs, but it seems to me it's at the very least, a significant loose end, if nothing else, in this case. And so I was wondering what your view is on that. I mean, the interest is a big component of what you're seeking here.
That's correct. And frankly, it had not been an issue between the parties, but I do understand that, and I'm happy to research that further. I think it was just assumed maybe on both sides that if we win, interest applies.
Well, I understand that, but I'm not sure we can necessarily proceed on that assumption when the law appears to be otherwise, at least as to the basis that it's being claimed now. And we can entertain a Rule 609 letter if you want to submit something addressing that point. And if you do, I mean, I think Mr. Whalen would be well within his rights to respond to that. I would appreciate it if you would do that sort of post haste, but I'm not going to set some formal deadline for that.
I will do that, Your Honor. I appreciate the allowance of that time. I will do that post haste.
You may continue.
Could you please address your position on the set off of the unpaid child support arrearages with the mortgage payments that the husband made?
Yes, Your Honor. My initial argument is that there was no evidence admitted. You don't have anything in the record that substantiates the number that, well, at the time it was counsel below, she threw out a number that there was no support for in the record. She did this document dump. It was on the eve of the hearing, and I objected to that. There are only 2 transcripts in this case, as you know, And I objected, and I had not had a chance to review that. I thought it was inadmissible. I had deposed Mr. Clark, Ducis Tecum, and he produced a handful of documents. There were bills, electric bills, and a couple of mortgage payments. But these 2 3-ring binders that were full of bank statements of everything Mr. Clark had paid over the years, it was never admitted into evidence. It was not analyzed. I didn't have a chance to review it. I objected to the admissibility. So I guess that's my first argument, is that there's no basis for the court to have set off the alleged payments for mortgage and bills in lieu of child support payments. But also, I believe this is addressed in the reply brief, that the law does not provide the absent an agreement. And that's probably the second argument I would make. There was no agreement. I deposed Mr. Clark, and he said, no, there was nothing in writing. But I thought that this was probably going to work, but that's not the law. The court found that just the case had become cloudy, I believe is the word that Judge Fleetwood used, because it was so old. And he did not pay any heed to the facts or the law regarding set off against child support payments.
Do you have particular authority that would say that set off is not permitted as a matter of law in that circumstance? I mean, assuming you had good proof of what was paid on the mortgage, is there something that would preclude the use of it as a matter of law as a set off?
Only what we've cited in the briefs.
Which was, I mean, I've refreshed my record. I mean, I don't recall what it was, but I mean, did you cite, I mean, I can go look. I mean, did you cite specific cases
Yes.
to that effect?
Yes, and I'm sorry, I don't have that right at hand.
Well, that's fine. I mean, I can go look. I did at one point. It obviously didn't stick with me.
But I think absent an agreement, that I don't know of any law that allows a party just unilaterally to decide, okay, this is how I'm going to view this, without the person who is entitled to the child support payments agreeing to it.
Okay.
Counsel, I've got a question, if I could, because it's not clear to me in this record. Was there ever a indirect contempt proceeding brought by your client against him in order to collect any of these arrearages?
Yes, I filed a motion for an order to show cause why Mr. Clark shouldn't be held in contempt.
And what came of that?
It was set for hearing, and this is in our statement of facts, set for hearing, but on the date of the hearing, all parties and counsel were present, and Judge Fleetwood broke his tooth, and so we couldn't proceed with the hearing. And then it was never reset or followed up on, and I pursued that. I thought we needed a hearing. We were ready to go. That was going to be the evidentiary hearing. But it was canceled because he needed to get to the dentist immediately. And it was just never reset. That's one of our arguments, that the district court did not monitor this case properly, and that's why it has dragged on.
So did you and your client just drop it?
No, I continued to request an evidentiary hearing. There are 2 records, and I continued to request an evidentiary hearing, and it was denied. Okay. In the final result, Judge Fleetwood said, this case is cloudy, it's old, it's so old there must have been an agreement, since this is where we are. And he found that the if there had been an order of contempt, it was withdrawn. Well, there was no order because there was no hearing. The court just dropped it. And even though I was asking for follow through.
Thank you.
Yeah,
Thank you.
you've gone into your rebuttal time, so we'll give Mr. Whalen a chance here.
Thank you, Your Honor.
Morning. May it please the court, Michael Whalen on behalf of the appellee, Kenneth Clark. If I may-
Before you get rolling, do you agree with Ms. Webb's position that you are no longer arguing that dormancy applies here? Do you agree with that? Okay. Given that, does the case have to go back because the maintenance payments are now in play, and that would affect the other issues, including the division of the marital assets, being the proceeds from the sale of the house?
No, I don't believe so, Your Honor. We, as addressed in my brief, we believe that Judge Fleetwood made the correct ruling, but it was on an incorrect basis. From the Kansas case of Edgar versus Edgar, this court has held previously a couple of times that temporary maintenance is not a final order. That was also, I believe, affirmed in the Kansas Supreme Court case Brown, but that it is a pendente light, and I'm probably mispronouncing it because I never took Latin.
Pendente lite.
Very good. Thank you, Judge Hill. And basically what it says, because it's not a final order, when it comes time for a final order, the court has the discretion to review the payments and can find that it can dismiss arrearages, it can forgive some of the ordered payments. It gives the district court discretion in assessing the prior temporary order and the outcomes therefrom. So we don't believe that it's that dormancy necessarily applies, but the pendente lite would. And that's the position that we've taken. And granted, this was a new argument for appellant on appeal. We believe that it falls under one of the exceptions, and that being the third exception, that the judge made a correct ruling, but for the wrong reason. I would also submit that it falls under the other two exceptions as far as fulfilling justice, and I'm blanking on the third at the moment, but we believe that we've properly addressed this argument as being raised for the first time on appeal.
Okay. Now you can make the argument you intended to make before I diverted you.
Very good. Thank you, Your Honor. A couple of things that I want to address the court brought up. Set off, I'll start with the child support issue first. Can it be set off? Yes, it can. The district court has great discretion in precise. We point out that these matters are not subject to a precise division of time and money for child support. These are not computations to be made with scientific accuracy down to the penny. And I'm quoting from the marriage of Skovzek, 31 Canap 2nd 606. And so I believe the court has the discretion to look at the entire financial picture or what's happened in the past and can create a set off. There isn't a statutory requirement, as far as I know, that the only way child support can be calculated is based on processed payments that go through the Kansas Payment Center or through some other state submission. And I think that's the situation that we have here. There was a known agreement. I mean, and this is partially based on the district court's finding that there was a known agreement between the parties that Mr. Clark, instead of paying technical maintenance and child support, was paying both the mortgage, the child expenses, and utilities for the home. This was also in an exhibit that was added to the record by appellant. There was a letter from Ms. Bloom Clark to Judge Vining in 2005, within which she stated, "I was aware of the divorce when it was finalized in 2002. Mr. Clark is not necessarily making payments of child support and maintenance, but he is paying the mortgage and household and house expenses and child expenses." So there is an acknowledgement in writing in an exhibit, and it's Exhibit M, I believe, that supports the district court's finding that this was a known agreement, that this was a process that had been accepted by the appellant.
But Mr. Whalen, on that point, apart from the letter, was there evidence presented to the court that would support the idea that there was an agreement, an actual meeting of the minds on that?
Well, I think
Or
there's
was
a
there-
letter, and I think there's 18 years of accepted practice.
Okay, that's acquiescence, maybe. Does that ripen into an agreement?
I believe that it does, Your Honor. Because if not, she had 18 years in order to file a motion for contempt, to do enforcement to get these payments. The fact that she sat idle, I don't think you can characterize 18 years of a system going on as just mere acquiescence. The argument may have been valid if this had been brought up 1 or 2 years after the situation started, but I think it most definitely does become can be characterized as an agreement for that length of time.
Well, let me follow up on that. At least with respect to the child support, can there be an agreement of the divorcing parties to alter the court-ordered child support on their own?
Generally not, but I don't believe that it was shown that there was a change in the amount of child support that was provided. If we look at the records that were submitted, and it's inaccurate to say that the documents, that there were financial documents that were submitted on December 9 in that it was just a blanket drop of documents. On the same date that appellant was talking about the hearing in front of the court, Mr. Clark filed a petitioner supplemental information as required by the court on that same day, which is at page 128 of volume 1. It's a 4-page document that lays out all of the payments that are substantiated by documentation that were submitted to the court, which were never contested by the appellant. So I think we can show that he actually paid in excess of what the court orders were overall. And I don't think that necessarily becomes a modification of the paid child support.
I looked at some of the documents, and I'm not a financial wizard. It looked to me as if what they showed was, at least on a monthly basis, that he was paying somewhat less than the total of the maintenance and the support. Am I mistaken in that?
During the initial time period, I believe that's correct, Your Honor. However, his payments went on for another, I believe, 10 years from the time the last child achieved the age of majority. And so there were continued payments. And while it may not have specifically been the exact payments in the court papers, a significant amount in excess was paid overall to the appellant.
Okay, I see what you're saying.
Thank you. I just wanted to make one note There was a question about the motion to show cause. There's one significant problem with that motion to show cause or for contempt to enforce these payments. It was e-filed and notice was given by electronic filing. Mr. Clark was never served personally with the contempt citation or the contempt motion. Page 70 and 71 of volume 1 show that document and that it was submitted by e-file. And an attorney cannot accept service on behalf of a client when personal service is required. So that may have played into this as well. Also, the issues that were raised in the contempt site or the contempt motion were ordered to be addressed through mediation by the court. So it wasn't that it was just completely ignored. This was then submitted as part of mediation, but the document itself was never personally served on Mr. Clark. And as far as, an issue's been raised regarding due process, that there wasn't an evidentiary hearing. If you look at the motion for judgment that was filed by appellant, it states specifically that the court has enough evidence before it to rule on both the maintenance and the child support and ask for a ruling without evidentiary hearing. At the hearing on December 19th, Mr. Clark informed the court, counsel for appellant stated, we want an evidentiary hearing. She needs to be able to talk about her expenses, raising the children and her involvement. And counsel for Mr. Clark informed the court, we'd be willing to stipulate to any of the appellant's statements about expenses and what she went through. That opportunity was given for a proffer and a stipulation that was announced on the record. So I think that we have a little bit of an issue in that all of the information was there to allow the court to make the ruling that it did.
It seems to me that apart from, again, the number crunching here, that an evidentiary hearing would have been at the very least desirable. And it seems to me probably necessary as to the scope of the agreement or the acquiescence or the understanding or whatever it was that your client suggests his ex-wife had. Yeah. Is it your view that the district court had enough information without an evidentiary hearing to make that determination as to the scope of the agreement? Huh?
Yes, I do, Your Honor. I believe that there was enough. I think we have the admitted letter from the appellant herself saying this is what's going on, and I am not going to hire an attorney. This was also in the letter. This was a letter sent to Judge Vining. It was ex parte communication requesting legal advice from the judge. But within that letter, Ms. Bloom Clark stated, this is what is going on. He's making payments covering the house, the mortgage, and our expenses. I am not going to hire an attorney, or I don't want to hire an attorney because I've been burned before. So she knew this was an issue, but made a choice to not pursue it, to not have representation until 2015, 13 years after the fact.
I appreciate that the letter may signify that, but my question was more precisely about whatever the nature of the quote agreement or understanding was as to substituting mortgage and utility payments and other stuff for the court ordered maintenance and support.
Well, I believe
does that require some sort of an evidentiary hearing?
I don't believe so, Your Honor. When you're talking about 18 years of a system in place without notice or objection, I think an agreement can be.
Well, was the agreement that any difference would be deferred, or was she just saying that's an adequate substitute and you don't need to make up any difference?
I think it's,
Well, I mean-
I honestly, Your Honor, I believe that it's more than significant that it went on for so long unchallenged and unquestioned. And that
well,
you
but that
can
it
make
depends
that,
on what the agreement was. What was her understanding? That he eventually would, I think that the term I've heard people in this field use is true up at the end and make up the difference? Or was it simply that that was sufficient? And if there was any other underpayment, that was okay?
I think it was just flat acceptance, Your Honor. I mean, I
Well,
really do.
I mean, besides clairvoyance, what do you base that on?
The statement from appellant, this is what's going on and I'm not going to challenge it or hire an attorney or get involved. And then a subsequent
Okay.
15 years. I think I'm repeating myself, Your Honor, and I
Well, and
apologize.
I'm repeating myself, but
Yes, Your
okay. And you've actually used up your time. If you want to take a minute just to sum up, that would be fine.
Your Honors, we have a case here that was ignored for a long time. And I believe it was only revived because of Judge Fleetwood finding it as something that was sitting. The court had substantial information and enough information to apply its discretion in division of property and for the rulings that it made. And I believe the law backs us up as contained within my brief. Thank you, Your Honors.
Thank you. Ms. Webb, we cut into your rebuttal time a little bit at the start. You have about 4 minutes left. And we went
Thank you.
over a little bit with Mr. Whalen, but you kind of got equal time here. You got 4 minutes. So,
Oh, I appreciate that.
all right.
I'll just start by saying, let's not forget that Mr. Clark was and is an attorney. He had an unfair advantage over his wife, who was now raising 5 kids, a teacher, could not have possibly made the mortgage payments. And it benefited him to be making those payments because it nice property in Eastboro in Wichita. And he, according to Judge Fleetwood, was entitled to 40% of those proceeds. And my client gets 60% in lieu of all of the money she was owed. Let me correct one thing Mr. Whalen said. Mr. Clark was in fact served personally during his deposition with my motion for contempt. And that's a part of the record. The court reporter was taking notes. The sheriff's department entered the room and served him. And so he was served personally. It was later e-filed, so it was a record, but yes, he definitely got served personally. And the fact that Judge Fleetwood had addressed the need or the issues on the motion to show cause, he submitted that to mediation. That does not substitute for an evidentiary hearing where the facts can be known, especially from my client, who to this day hasn't had her day in court. Mr. Whalen also, the language from the letter that my client sent to Judge Vining is, Ken has never paid any child or spousal support, but makes our house payment and household bills instead. She was just advising Judge Vining of the situation, who's doing what, but she was reaching out because she was not represented by counsel. She couldn't find an attorney that would take on Attorney Clark in Sedgwick County. And it wasn't until 2015 that her mother asked me if I would take her case. But otherwise, I don't think she would have ever gotten counsel. But the language from that letter, it's a stretch. In fact, it misrepresents the language to say it was an agreement. And you're right. My client always thought that someday she would have justice, get a day in court, and the amounts owed that Mr. Clark had entered, the temporary order he drafted and got Judge Vining to sign it, and he never modified it. That's on him. And all these extraneous supposed facts that Mr. Whalen mentions, it's not evidence. They weren't facts that Judge Fleetwood should have considered.
Counsel, can I ask you a question, please?
Certainly, yes, Judge.
Don't we have literally hundreds of cases that say a litigant must do something to protect her rights? And here we've got the passage of time where your client actually took no steps to protect her rights other than send years into it a letter to one of the local judges. Am I being uncharacteristic wrong here, or am I misstating the evidence?
Of course, you're correct. There are hundreds of cases about sitting on one's rights, like latches and estoppel, et cetera. But of course, those are equitable concepts.
As are divorce cases. They sound inequity, do they not?
Yes, it is a court of equity. And if we're looking at whose hands are the most unclean, it's the attorney party in this case. But to your point, she in the temporary orders, who sat on the case? The petitioner, Mr. Clark. He's the one that didn't do anything to wrap it up. And I think it fell off the radar with the Supreme Court that I've always understood they monitor cases in the district court. So once Mr. Clark got his divorce and the case was bifurcated and he was free to remarry, that's what was wrong. The district court did not have, wasn't watching, Judge Fleetwood. Well, there just isn't any application of those doctrines in these circumstances. This is frankly a matter of law.
All right, thank you.
Okay.
Thank you,
You've gotten
John.
to the end of your time. I appreciate the arguments of counsel. We will take this under advisement and get out an opinion in due course. And we'll try to get it done much more rapidly than what happened in the district court. I can assure you. I would appreciate, Ms. Webb, if you want to follow up with a 609 letter on the legal source for interest on these payments. And Mr. Whalen, after she submits that, if you could promptly file any response that you want to make, I would appreciate that. We won't get to this like in the next week or two. So if you all could take care of that in that time, we would appreciate it. And with that, we'll close this argument and we'll get on to the next case. Thank you.
Thank you, Your Honor.
Honor.